Hello, this is the next in the series of presentations on the Jackson reforms to civil procedure in England and Wales, and this one is on cost capping. Now, on the face of it, this may seem to be a rather strange topic to pick under the Jackson reforms, because although Sir Rupert Jackson raised the subject of cost capping in his final report, the detail of this, alongside cost management generally, was left to the judiciary to be fleshed out, and the result of those further consultations on the subject was that there appeared to be no strong body of opinion that cost capping should be the normal way of controlling costs. Consequently, the pre-April 2013 regime has essentially been carried over into the new regime, and costs budgeting has triumphed over cost capping. But since cost capping is a component of the cost management regime, it is worth looking at it briefly. Now, up until now, cost capping orders have been made in a relatively small number of categories of case, such as public interest applications in the administrative court, see the CND and Prime Minister case, in group litigation, for instance, the nationwide organ group litigation, and in a very exceptional case, clinical negligence, and that's the Shepherd case. These pre-April 2013 cost-capping cases came to be codified in the rules that were put into place in 2009. And a further change in the current regime is that this has been redesignated from questions of costs to question of cost management, and so it's all been relocated from CPR 44 into CPR 3. Now, although cost capping is there, available within the armoury, available to cost judges, and since the overriding objective has been altered to make the control of costs more central to the whole idea of dealing with cases justly, it's possible that we might see a surge in applications for cost capping orders, even in types of case where they haven't hitherto been seen as being suitable. Now, at one time, there was a real judicial appetite for cost capping. For instance, in King and Telegraph Group, Lord Justice Brooke said, if defamation proceedings are initiated under a conditional fee agreement without after-the-event insurance cover, the master should, at the allocation stage, make an order analogous to orders made under Section 65 of the Arbitration Act 1996, that is, cost capping orders. In the ordinary course of things, this order would cover the normal costs of the litigation. So, in that type of case, Lord Justice Brooke thought that this would be the normal type of order. But subsequently, a more restrictive approach was urged by Mr. Justice Gage in the case of Smart and East Cheshire. He said in that case, in my judgment, the court should only consider making a cost cap order in such cases where the applicant shows by evidence that there is a real and substantial risk that without such an order, costs will be disproportionately or unreasonably incurred, and that this risk may not be managed by conventional case management and detailed assessment of costs after trial. And also, it's just to make such an order. Now, it seems to me that it's unnecessary to ascribe such a test general headings of exceptional circumstances, and I would expect, said Mr. Justice Gage, that in the ordinary run of actions it would be rare for this test to be satisfied. But it's impossible to predict, he said, all the circumstances in which it may be said to arise. Low value claims will inevitably mean a higher proportion of cost to value than high value claims. Some high value claims will involve greater factual and legal complexities than others. So that restrictive view later found expression in the Rules of Court introduced in 2009, and in another libel case, Peacock and MGN, Mr. Justice Eadie recognised that the new rules comprised, he said, a more restrictive approach to cost capping, and he added, thus it's clear that, at least for the moment, the proactive and interventionist approach recommended by Lord Justice Brooke in King is on the wane. The contrasting judicial viewpoint, exemplified by the cautious approach of Mr. Justice Gage in Smart, is now in the ascendant. Indeed, it's clearly reflected in the wording of the new rules, that is to say, the rules introduced in 2009. So it remains to be seen whether the revised overriding objective will turn that tide again. Now, moving on to the way in which, on the restrictive approach, the jurisdiction has been exercised, in Barr and Biffa Waste, Mr. Justice Coulston stated the principles, and they are as follows. A party seeking a cost-capping order will need to demonstrate on the evidence that such an order satisfies the criteria at sub-rule 4418. Now, those rules mirror the more restrictive approach outlined by Mr. Justice Gage in Smart. B. A case in which these criteria are satisfied is likely to be exceptional. That's from Mr. Justice Eadie's judgment in Peacock. C. The mere fact that there is the claimant who has a benefit of a conditional fee agreement and no after-the-event insurance cover will not, as of right, entitle a defendant to a cost-capping order. Now, that position must apply a fortiori where there is after-the-event insurance cover, but it is not, or it may well be, insufficient. On the other hand, the fact that there is either no ATE cover or inadequate ATE cover must be a relevant factor for the court to take into account in considering all the circumstances of the case. Now, fourthly, in cases where a group litigation order has been made, cost-capping orders may be made more commonly. So, turning to the terms of the rules as they apply after April 2013, a cost-capping order will limit future costs and disbursements which will be recoverable under an order for costs as between the parties. The practice direction continues to make it clear that the cost-capping order will only be made in exceptional circumstances. If the new overriding objective encourages a more proactive approach to cost-capping orders, therefore, it will only be in cases where the applicant can show exceptional circumstances. These rules do not apply to protective costs orders. In Corner House Research, it was established that protective costs orders may be made in public interest cases brought by applicants against public bodies, where the issues are of wider public interest, so that applicants should be, for that reason, heard without the fear that they might be unable to meet a costs order. In the Paradigm case, the applicant will have no private interest in the outcome of the proceedings. Now, protective costs orders limit the costs liabilities of the applicant. Now, cost-capping orders may be made in respect of the whole case, or where the issues are to be tried separately, for instance in a split trial with liability dealt with first and quantum second, in relation to several parts of the case. The substantive requirements of the rules reflect the judgment of Mr. Justice Gage in Smart. That is, the order may be made if it's in the interest of justice to do so, and if there's a substantial risk that without the costs order, the capping order, costs will be incurred disproportionately, and where cost control can't adequately be achieved by the use of the court's case management powers and a detailed assessment of costs. As to timing, the application should normally be made before or at the first case management conference, and if an application is made later, that will weigh against the applicant. Now, factors to be taken into account by the court are whether there's a substantial imbalance between the financial positions of each party, where the dealing with costs capping issue is likely to be disproportionate, the stage the proceedings have reached, and the balance of costs incurred as compared with costs yet to be incurred. Now, when assessing the quantum of the cap, Practice Direction 3F says the court will take into account the factors detailed in Rule 44.5. Now, that's presumably an error for CPR 44.43, which specifies what must be taken into account on an assessment of costs. Now, that's all we're going to cover on this presentation, save only to make a point about the VAT payable on a cost-capping order. Now, it appears from the case of Worley that the cap should be on the VAT exclusive element, and that the VAT should be added on top. So, for example, if the costs are capped at £10,000, the receiving party on an assessment could recover £10,000 plus VAT of £2,000, making a total recovery of £12,000. And that's all on this presentation. Thank you.